Well, we're talking about money laundering and the war against corruption this morning. My guest is Malachy Ugwummadu, who's a constitutional lawyer and former president of the CDHR. Good morning, and thank you so much for finding
Thank
time to
you.
come.
Compliments of the season.
I wish you the
Delighted to
same.
be here.
Absolutely. So I'd like us to begin with the contradiction with this debate. So I just told you about the EFCC saying it's done fantastically well in the number of convictions it's been able to secure in the past 1 year. You also heard Mr. Bauer saying that they have recovered 30 billion from the suspended Accountant General of the Federation. There are a lot of news as regards that, but on the contrary, there are still other damning reports that tells us that Nigeria still rates very high in the issue of money laundering and terror financing risks. Which of these reports do you believe?
Well, the two should be taken, perhaps with a pinch of salt. The reason for that is that the masquerade is dancing and assessing itself. The victims of the ferocity of his dance are also assessing the situation. And I'm talking of the victims of corruption in Nigeria. Those who are, whose lot and fortunes are clearly defined by that which has become almost a culture and institutionalized in our system. They want to see a drastic departure from what it has always been. They want to appreciate a radical departure from what it has been, which has cost them not just their future, but that of their children, to be able to heave a sigh of relief, as it is at the moment. It is gratifying to hear from the chairman of the Economic and Financial Crime Commission that they have done so much, and in relation to what the commission as an institution had done from inception, that is even huge. I guess that the challenge is that we have traveled so far in the woods and become not just accustomed, but immune to the direct implication of corruption, so much so that the general corrupt index assessment by independent organizations and institutions have not, taken us out of that bracket. But I think that what is clear is that the fight is on. It is on, perhaps not at the maximum level.
So it looks like we're doing more, but it's like the corruption itself is still more.
Clearly, what is not disputable is that we have traveled so far in the woods. I mean, it got to the point where even in critical environments and segments, I had the misfortune of delivering a lecture in one of the ivory towers in this country. And the students who were supposed to know came up with a position that clearly establishes that they have seen corruption as part of us. And that the discussions around it is to just understand the ramifications, but not that it should stop.
Yeah.
So those are students who are supposed to be idealistic and lean towards the ideals of society. But they have thrown their hands up in heaven, in defeat, accepting that whereas they may hear the ills about corruption, but it is clearly a way of life in Nigeria. I think that is where the challenge lies, so much so that what we might need to do is not just to scale, raise the bars and intensify the effort. It is to find a way, creative at that, to let the people own this fight. At the moment, it's still a sing-song in the ears of so many people. I'm talking of where it becomes part of individual fight to rid corruption in our society, and it can be done. But before it is done, there must be clear indication that that is the policy trust, that is the direction we are headed, and that is where we desire to go.
There's, however, the challenge of the political coloration and bias that come with it. For instance, the latest report we just showed, the accused is saying it's the work of his enemies. Some people have a political coloration to it, that this is the incumbent government gunning down the campaign DG of a rising political party ahead the general election. But this kick-started in 2019. That's over 2 years. I'd like us to talk about the Money Laundering Act itself, because the president signed the 2022 version into law earlier this year. I think primarily, an individual cannot receive the sum above 5 million naira, and for organization, 10 million naira, without passing through a financial institution. I'd like us to talk about the corruption in it, because in this particular case, it's not about what the money was used for, it's about how the money was received. Is this something that everybody knows about, and how important it is, is it in the fight against corruption in Nigeria?
Well, your question is already loaded, but let's take it seriatim from where you started. It is that there is a political coloration. This is a political season. If it had come a week to the elections, it will still be political. It will still have political colorations. But the issues are, were they identified criminal infractions? Yes, they were. Were they body of evidence to prove the elements of those criminal infractions? The court says yes. Has the person in question, did he therefore plead what we call a locutus to reduce it? Yes, he did. Does he have a right of appeal? Certainly, it's still available to him, and I imagine that he might want to exploit. At the end of the day, what you will be interested in is, this is a criminal trial. It didn't end in the media. It went to court. By the time the court concludes what we call trial, and then adjourns for judgment, usually the court requires that it should not exceed 90 days. From the end of address, that is when trial ended, and when the court is addressed, in law we say final written addresses on the two positions. It should not exceed 90 days before you deliver. In short, if it's going to exceed 90 days, either the court or the parties involved through their counsel is expected to remind the court that, please, we have exceeded the 90 days constitutionally provided time limit. Within quick judgment ought to be given. If you fail to do that, it becomes one of the grounds of appeal. But this is too technical to dig into any further. What is to be taken is that if that time fell within the election period, it's neither here nor there to argue whether, in any case, this didn't start. In short, he wasn't the DG when this trial started.
You are familiar with court process.
Yes.
Is it possible that the judgment was expedited because of elections?
Oh, well, there is a law.
In order to indict the Labour Party?
Well, these are extrapolations that you cannot take away from the table, but there is a law that has come into effect, in short, signed by the government he served. I'm talking of Jonathan. It was a patent gift, which President Jonathan signed on the 13th of May, 2015. It is known as the Administration of Criminal Justice Act. That act demands daily trials with respect to criminal matters. It puts an end to frivolous adjournments and limits it to 5 maximum. Even if the matter is to drag more than 5 or 10 years, it must not exceed 5. It calls for daily trial and a lot of other innovations to guarantee speedy dispensation of justice. That law is still an extant law and operational in our criminal jurisprudence. So, whether advantage of the law has been taken now, or indeed the matter was already ripe for judgment, the facts and the records of the court and the proceedings of the courts will show that clearly. You cannot completely take away these political innuendos and insinuations. You cannot. However, you must turn back and return to those initial questions I asked. And I like to go to your next point, which is We've talked about, you raised the point about whether it has political corruption.
Yes.
You then went whether this is sufficient to tackle the magnitude of
the
corruption. Well, what we have seen so far is that it's not only bribery and corruption or stealing, direct stealing from the tilt of public funds that constitute corruption. We have so soon come across all the forms and ramifications of corruption, including money laundering. And that is where you acquire illicit funds and take it through a process that turns it out as if it is a legitimately earned funds. So what does the law say? What does the society say through the law? The society is saying, given the propensity of our people and the drive for primitive accumulation, which has subjected the majority of Nigerians to very excruciating hardship, we have found that what obtains is that people in the corridors of power constitute themselves into distribution agencies and dispense money in cash as though there are no regulations and no better ways of doing it. Therefore, if you as an individual will have to receive or accept or give money in excess of 5 million, please do it through the
financial institution,
and that's the bank.
Let me try to bring in another guest on the program who's also been involved in advocacy campaign for years, and his activities have entailed promotion of accountability and transparency in governance. Larry Suraj is Chairman, Human and Environmental Development Agenda. Thank you for joining us this morning, Mr. Suraj.
Thank you very much. Thank you for having me. Good morning.
Good morning. So I'm sure that you'll follow this conversation through in the past 15 minutes thereabout. I just would like you to continue from addressing the many issues that have, come up. Do you consider that the Okupe sentence is a slap on the wrist? I'm not sure he got the maximum sentence. It would seem that there are varying degrees to money laundering, as it were.
Yeah, thank you very much. And I would want to also salute my brother there for giving that very clear and also, guiding light to the stages and also the position of the law, especially with the Administration of Criminal Justice Act, that has actually also many times been observed in breach by both the judicial officers, looking at our judges, and many times both the defense and prosecuting counsels in terms of failing to limit the adjournment issues to, just like he said, 5 adjournments. And sometimes they deliberately even give adjournment that takes more than even sometimes close to a year or more than a year, including the Supreme Court in Nigeria. But when you look at the judge and the decision, I think the judge has done to a very large extent a disservice to the country. Also, the unfortunate situation that is also repeating what we have, like the John Yakubu case, who was given 6 months imprisonment or the payment of paltry amount of money to easily escape the sentencing by just even paying the money before leaving the court. And the same thing happened to the former governor of Edo State, Lucky Ugwummadu, who was also treated in the same manner, having been charged with billions of naira in corruption and money laundering. And this is the same situation where someone is being charged with about 702 million naira corruption, money laundering, and also abuse of office. And what you then have is this 15 million naira sentence. The 15 million naira.
I think it's 13 million, Mr. Suraj.
Yeah, 13 million. Sorry. This is even not going to cover the cost of EFCC in that case over the years. At the end of the day, the country continues to lose. So ultimately, the country is lost more than 900 or close to a billion naira on this case. Even the cost of the time of the judge to sit even in the court, the cost of the court services and the payment of the judge's salary is not covered with this kind of, sentencing and the judgment that has just been delivered. And I think the judiciary needs to be very seriously sensitive to the situation of the country. Otherwise, we're not going to have even resources sufficient enough to adequately treat our judges in the way that will be commensurate with international standard. If the judiciary and the judges would allow political and even bureaucrat officers to escape with this kind of corruption, this does nothing other than encouraging corruption within the system. This also encourages impunity. So if someone is sure he can afford to steal the kind of amount of money that is attributed, so we should be expecting with the over 30 billion recovered from Idris Ahmed, with the allegation that he's been involved in over 180 billion naira corruption and ACE. If he's sentenced, he would just be asked to pay 1 billion naira, or you would go to jail for 2 years or 3 years. And that would just be paid by these characters because they still have the huge
I hear you, Mr. Suraj. You are noting that the country is spending tens of millions of naira that it would have been spent on infrastructure to investigate and prosecute corrupt politicians. But then the best we also get here, like he has mentioned, is that only a fraction of this corruption money is asked to be paid as fine. And then you heard his family member also plead leniency, talk about his old age, his sicknesses, and the fact that what was done in error. I'd like us to speak to how fair the criminal justice system is. You know, some would say it favors the rich, because if it was someone who didn't have as much name and as much money, perhaps such an individual would be rotting behind the jails. I mean, awaiting trial for many years. What's the implication of this on the war on corruption? I mean, the war against corruption in Nigeria?
Your question takes us to an aspect of jurisprudence that we cannot completely dissect here. However, it is important to take advantage of that question to insist, perhaps given where some of us are coming from, that the law itself has proved to be tilted more in favor of the ruling class as against the masses. What it does is to contrive situations in a way that enables the rich, the powerful, to escape the long arms of the law much more easily than it is possible with the poor. Speaking realistically now. But the good news here is that incrementally, I know that this is precisely not what the Nigerian people want or what Nigeria itself deserves. Incrementally, the society is showing its resentment to acts of corruption. Have we managed to utilize this number of cases to address the challenge of corruption that we have in our country? Certainly, it is like a drop in the ocean. Does it, the successes we have recorded, has it approximated a kind of milestone enough to drive the message in the consciousness of our people that this is not the route to travel? I don't think so. So if you talk about the implication, taking advantage of some of these cases, and I like to thank Comrade Suraj for reading out this. It's a long trajectory we've had, from the Bori to even the, is it Auditor General?
The
Accountant General. If you take a look at what is alleged to have taken and what is recovered, I think Nigerians would have been better served if they were not told. Meanwhile, it has taken the commission, talking of EFCC now, so much to even recover that. Even the law has developed where you now have civil forfeitures. In other words, you don't need to travel the whole route of criminal investigation, trial, conviction, sentencing before you forfeit proceeds of crime. There are other means through civil engagement where you can also recover some of those goods. So all of those are in place. But like I keep saying, we went too far that you need a surgical, very radical and urgent, which is precisely why when we see the gladiators...
When you say radical and urgent, I don't think that the judiciary has the capacity to make that happen. I mean, for instance, this case has been on since 2019. It even loses its steam.
Let me help you.
When the prosecution takes so long.
If you are concerned about the present dispensation in the judiciary, well, you could be excused. But there are moments in this country when we have the tribes of Justice Oputa, Kayode Esho, Aniagolo, so many. They call it the golden age of the Supreme Court. You could see that these were law lords who were bent on savaging the country using the instrumentalities of the law. And they were seen as activist lawyers who were not just, who did not just subscribe to the positivist perception of law or ideology of the law. They didn't just see the law as it is. They saw the law as it ought to be, given the peculiar circumstances of the society they find. And that is when it becomes necessary. That is when it becomes relevant. If the law is unable to solve the problem of the society and advance it from point A to point B, then we have just created yet another bureaucracy and system of civilized behavior that does not take us
I hear you, Mr. Ugwummadu. Mr. Suraj, just before we go on break, I'd like you to speak to the logic and the public perception to this particular case. You highlighted earlier about the amount of money that have been spent during the time of prosecution versus how much fine that the former aide to the former president was given. I also want you to now put into consideration what the public perception is. So you hear people say, oh, it's a political vendetta. It's because he's a campaign director of a particular political party. You ask yourself, to what end? What has the AFCC achieved here? Mr. Suraj, are you there?
I'm here. Can you hear me?
I can hear you. Did you get the question?
Okay. Yes, I got the question. I think this is actually one of the most disservice that quite a number of these, I think, advocates of, let it just be. And those who would want to say, when it is my thief, it is not a thief. Or those that would want to conclude that, oh, why not catch your own thief before the other? One of the greatest disservice that would be done to both the country, to the judiciary, and even to the law enforcement agencies is to come to this conclusion. I can remember that the charges against Okupe was filed as far back as December 2018. In court. This was at a time when it was still a PDP person. This was at a time when there was nothing that could be called Labour Party and Peter Obi as at the time that it was in court. And the moment that the cases get to court, I think this is the level of education that we would actually need to use the media to also assist some of these people to understand. The moment that the case gets into court, it is solely in the hands of the judiciary many times to determine the length of the prosecution and trial. It is not in the hands of either the executive or even the legislature anymore, except after they have before they could do before filing the charges, or the law that the legislature would have passed in terms of, the administration of the trial and the rest of that. For some people to use that as a basis of defense, not just for the corrupt in the system. Are they saying that Okupe did not steal the money again, or that Okupe was not guilty of the crime? So people are not bothered about the offense anymore. They are only bothered about the pecuniary personal benefit that is associated with either their candidate or their party. And for that reason, people who have sinned in the past, because he's the campaign director for Peter Obi or for Atiku or for Showore or for any other party, and for that reason, they should not actually stand trial to answer for their crime. And I think this is most unfortunate. And I think the media should not just also give it as much as we can, not give it any form of relevance, but to rather educate the people that we can't actually get out of the current debacle if we continue in that kind of trajectory and narrative. The fact of the matter is, he who must have sinned in the past should answer for your sin, no matter who you belong. And the people who are associated with Buhari now should also be made to answer for the atrocities that will be committed between 2015 and 2023, when they will be leaving office. And it doesn't matter if they either join the ruling government or they form opposition. We can't afford to allow people deceive the system. Still now, when you're here, and the moment you are brought to book, you run to opposition and then claim persecution. I don't see any justification and any reason to start discussing, this very mundane and pedantic issue.